Do the religious beliefs of Supreme Court justices influence their legal opinions? A straightforward question, and you'd think there might be a clear answer, but of course the answer is elusive, and the relationship between religion and judicial philosophy is elusive indeed. When Nadine first asked this question, there were 5 Catholics, 2 Protestants, and 2 Jews on the Supreme Court. Now there are 6 Catholics and 3 Jews. Obviously, there's not a direct correlation between religion and jurisprudence. One Catholic justice, Sonia Sotomayor, votes more frequently with the 3 Jewish justices than she does with her fellow Catholics. Another Catholic, Anthony Kennedy, sometimes joins the liberal bloc. So religion per se doesn't make a difference. There have been progressive Catholic justices like William Brennan and Frank Murphy, and conservative Catholics like Pierce Butler. The Jews on the Supreme Court have tended to be progressive, but that may be because they've come from more progressive Jewish traditions, such as Brandeis and Cardozo. So obviously, judicial philosophy by itself is more important than religion, but it's clear that religious background can, in subtle ways, influence judicial philosophy. And that's the question I want to explore this morning, and then have a conversation with you about this question, because I certainly don't know the answer, and I know the wisdom and intellectual energy in this room will help cast light on it. I want to start by broadly exploring the proposition more generally, and then focus on how religion influences judicial philosophy in cases involving the separation of church and state. So I said judicial philosophy is more important than religion, and I would say broadly that there are 3 strands of judicial conservatism among the 5 Catholic conservative justices, who could also be called the 5 conservative Catholic justices. First, there are the pro-executive power conservatives, and in that group I would put Chief Justice Roberts, Justice Samuel Alito, and Justice Antonin Scalia. Then there's the libertarian, Anthony Kennedy, who's liberal both in cases involving individual rights, like gay marriage and abortion, and those involving economic rights, like the healthcare case. And then there's the Tea Party conservative Clarence Thomas, and I say that just descriptively to describe someone who is both socially and economically conservative. Among the 5 conservative justices, 3 judicial philosophies, and yet all of them are Catholics. Among the liberals, I would devise the judicial philosophies as the pragmatist, Justice Stephen Breyer, the minimalist, Justice Ruth Bader Ginsburg, a Brandeisian doctrinalist, Justice Elena Kagan, and there was an appreciative giggle, I know. That's the highest praise I can bestow, because my hero, of course, is Justice Brandeis, and in all hard questions, I do ask myself, WWBD, what would Brandeis do? And I think Justice Kagan is very much in his tradition. And then Justice Sotomayor shows a moving concern for real people and for the poor. When I thought of her, I thought of the division in the papacy between Benedict and Francis, and if she's the Catholic Francis against the more Benedictine conservatives. How much does each of these justices find that their philosophy is influenced by their religion? To answer that question, first I wanted to think historically of times when there was a clear correlation between religion and judicial philosophy, and for me the clearest case is Buck versus Bell, the famous or infamous case where the Supreme Court upheld eugenics laws in 1927. In his majority opinion, Justice Oliver Wendell Holmes memorably said that it is better for all the world if instead of promulgating their ill-gotten kind, imbeciles be sterilized, and then he concluded 3 generations of imbeciles is enough. We know that Holmes didn't uphold these laws reluctantly. He wrote to his friend Harold Lasky after handing down the decision, "This morning I upheld the law mandating the sterilization of imbeciles. Nothing I've done all week has given me so much pleasure." We know that because Holmes, there was a gasp as opposed to an appreciative giggle. Holmes was an enthusiastic eugenicist who believed passionately that only the sterilization of imbeciles could ensure the purification of the race. But Holmes was not alone in his enthusiasm for eugenics. Theodore Roosevelt was an enthusiastic eugenicist, as were all of the liberal Protestant, Catholic, and Jewish denominations of the time. The only noted opponents of eugenics among religious leaders were the more conservative denominations, both Catholics, Protestants, and Jews. And that is why the only dissenter in the Buck versus Bell case was Pierce Butler, a devout Catholic who was clearly moved by his doctrinal opposition to eugenics. I know this, incidentally, because, as it happens, my wife, Christine Rosen, has written the definitive book about the attitude of religious leaders at the turn of the last century toward eugenics laws. The book is called Preaching Eugenics, and Christine shows in riveting detail just how much of a progressive enthusiasm this was, much like our techno-positivism in Silicon Valley today. All of the good progressives among religious denominations and all the main progressive religious leaders would enthusiastically advocate the virtues of eugenics from their mainstream pulpits. So in Buck and Bell, Butler was clearly motivated by his Catholicism, and Holmes, I think, was motivated not by his progressivism, because Holmes was no progressive. He was a Nietzschean aristocratic nihilist who had contempt for what he called the thick-fingered clowns we call the people. He said, if my fellow citizens want to go to hell, I will help them. And he voted to uphold eugenics laws, just as he voted to uphold almost all laws, including some of the darkest ever passed by American legislatures, because of his belief that unless judges almost completely deferred to democratic majorities and allowed the strong to impose their will on the weak by majority vote, then open violence would erupt. And I think this dark vision of Holmes's came not so much from his religion, because his father was a Unitarian of the mildest kind, the aristocrat of the breakfast table, and who wrote those wonderful comic essays for The Atlantic, but more from his experience in the Civil War, which so convinced him of the futility of ideals of any kind that he abandoned the mild abolitionism of his mother and became someone who believed that might made right and the strong had to crush the weak, and that it was only in allowing them to do so that democracy was possible. So you could call this a religious sensibility of sort. It was more a philosophical one, deeply entrenched with his extremely abstinent judicial philosophy, and in this sense helps to explain his vote in Buck and Bell. So, maybe that's a bit too complex, but I think Buck and Bell is a case where religious background influences philosophy in the subtle ways. Ultimately, philosophy rules, but background of all kind, including in Holmes's case centrally, his defining experience in the Civil War helps explain the votes in the case. What do the justices themselves say about whether religion influences their jurisprudence? Justice Antonin Scalia has written extensively that his own Catholic faith could never influence his jurisprudence, and if he thought for a moment that it might, that he would resign. If, for example, the church forbade the death penalty, he, as a judge, would feel unable to sign a death warrant because he believes that his religious commitments trump his judicial and positive law ones, but in Scalia's views, this is not compelled by church doctrine. Interestingly, of course, not all scholars have agreed with Scalia. An illuminating article by George Canar called The Constitutional Catechism of Antonin Scalia equates the devout Catholicism of Scalia's youth, where he went to Xavier Military Academy in Queens and talked passionately about the need of young Catholic intellectuals to become crusaders for a conservative Catholic position, how all this, Canar says, is influenced or reflected in Scalia's formalistic originalism, which believes that a judge is most principled when he commits himself in advance to certain objective rules and then forces himself to suppress temptation, to overcome his personal preferences, and to submit to the authority of the constitutional text. Canar thinks that the Catholicism and the originalism are actually entwined. Other justices have been more open in acknowledging a connection between their religious backgrounds and their jurisprudence. At a public interview at the Sixth and I Synagogue here in Washington a few years ago, I interviewed Justice Stephen Breyer, and an audience member asked Breyer whether his religion influenced his jurisprudence. He said he didn't see how it couldn't, because it shaped who he is, just as other aspects of his background influence his world view. There are more specific examples of religion influencing particular aspects of life on the court. Justice Ginsburg has said that religion was an important part of her growing up, but doesn't dictate her views. But Jewish holidays were not observed at the court when she arrived. She and Justice Breyer were initially rebuffed when they asked that a change be made, but today the court is closed for major Jewish holidays. And Ginsburg is also proud that Jews were among the founders of the NAACP, which in her view shows that Jews can identify with discrimination and oppression, and in her chambers there's a Hebrew sign that expresses her Jewish heritage: justice, justice shalt thou pursue. I said, having broadly sketched the question, I want to focus on the justice's attitude in separation of church and state cases and ask whether there's any sense in which their religious background influences their judicial philosophy in these cases, in particular in cases involving the Establishment Clause and free exercise of religion. Broadly, I see three categories of justices in religion cases today, and I would call them: first, the religious supremacists; second, the strict separationists; and third, the partisans of religious neutrality. The supremacists yearn for and endorse open state endorsement of religion and think there's nothing wrong with school prayer and other religious expression by the state as long as the state is neutral among religions. Second, the strict separationists believe that any breach at all in the wall is between church and state is impermissible, and in their more rigorous forms think that even in God we trust on the currency or the Pledge of Allegiance is impermissible. And third, a burgeoning new group of judges and scholars and perhaps justices identify with the position of religious neutrality. And this position holds that private religious expression is fine, public religious expression is impermissible, and hard cases involve deciding whether private choice rather than public endorsement is determining the direction of school funds. So under the neutralist position, vouchers and charitable choice are okay as long as the government makes funds available to religious and non-religious groups on equal terms, and it's private individuals who ultimately determine the destination of the funds. Obviously, all the hard cases are on the line in determining whether or not there's state endorsement. In, for example, the Arizona case involving the tax credit for institutions that could allow parents to take their money to religious or non-religious schools, the majority, it was decided on standing grounds, but it was an open question whether or not the state was being neutral or whether it was putting its thumb on the scales. How did the justices' religious backgrounds track their positions in these three categories? Broadly, I guess I'd place in the supremacist category certainly Justices Scalia and Thomas, and the Roberts and Alito have not heard a major Establishment Clause case along these lines, but they've signaled a sympathy for supremacism. Among the strict separationists, I think Justice Ginsburg is the leader. And among the partisans of neutrality, I think that Justice Breyer, who's signaled a willingness to accept some public expression of religion but not others in the Ten Commandments cases, might fall. And Justice Kagan seems to me, by her vote in the Arizona case, to be more of a neutrality partisan than a separationist, although, as I say, the question wasn't squarely posed. She did say in that case that she had an endorsement for religious neutrality. She had a great hypothetical. She said, suppose a state desires to reward Jews by, say, $500 a year for their religious devotion. Should the nature of the taxpayer's concerns vary if the state allows Jews to claim the aid on their tax returns in lieu of receiving an annual stipend? The court today says they do, but that's wrong. The effect of each form of subsidy is the same on the public fisc and on those who contribute to it. And then she concludes by saying the casualty is a historic and vital method of enforcing the Constitution's guarantee of religious neutrality.